Good morning and welcome in to another episode of the After Parties Me, the Jury segment. I am Tam, your host, not your lawyer, but your nosy best friend. And this is where you come to get all the courtroom tea served piping hot. Today is day 2 of us reviewing the Karen Reed trial sidebars. We will be reviewing trial 1, day 4 today, and day 4 is a 2-part video. The first part in court with firefighter Katie McLaughlin on the stand, and part 2 is the view, where they go and view the property at 34 Fairview Road. Good morning, Lincoln. Thank you for joining me this morning. We're going to jump right into it. If you don't have any questions, I already set it up for you. So we're going to go ahead and jump right into the first video. Just like last week, I will pause throughout the video if I feel like there's some explanation or background needed. So just know that this is day 4 of trial 1. Katie McLaughlin, who was a firefighter that came to the scene of the crime that morning. She is on the stand, and her testimony was amazing. Not her testimony, but the cross was amazing. So here we go. Let's get right to it.
Norfolk. Join in, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts.
Good morning. Come closer to the microphones, please. So a few things. So I was given copies, I think, of Exhibits 26 and 379 from the defense this morning.
Starting
Do
right
those
off
contain all of the videos that you intend to introduce as evidence?
I provided the court with the copies of the ones that we had put side by side.
Okay. I want all the ones that you intend to introduce. I don't want surprises like this. So I know you can't get them today. That's what I thought. It was clear I wanted to spend the time this weekend reviewing them.
You want all of our exhibits for the rest of trial?
The video ones. The ones that you intend.
Of the side by side?
Whatever you're playing for the jury, not the print ones. I'm not concerned about the print ones.
Anything that's video.
Anything that's video.
I believe the Commonwealth already admitted the rest of the just regular dashcam videos.
So nothing really is in evidence, and that's part of what I'll talk about here for a minute as well. Mr. Lally, I would like at least the corresponding Commonwealth dashcam videos that the Commonwealth has, the original dashcam videos that the Commonwealth has introduced. That's one. The second.
So this is Judge Cannone explaining to the defense that she wants to review all of the videos that they intend to put into evidence. If they tweaked it at all, she wants to see it. So whether or not the Commonwealth has already introduced these videos, if they have made any changes to them, she wants to see them before she allows them to be admitted into evidence. So that's what they're discussing here. The female voices that you hear are Judge Cannone and Attorney Little, and the male voice that you hear is Attorney Alan Jackson.
Second thing is yesterday, Mr. Jackson, you referred to the court reporter as Nancy. We are much more formal than that here generally. But my big concern is that I've known Madam Court Reporter for 35 years. I've never called her by name, particularly in a case where people's personal information has been put about on the internet. I cannot allow that, all right? I don't think you meant anything by it.
I certainly didn't.
I am not saying that you did. We have to be extra careful about that. The third thing is, please come to Sidebar before any videos are played that I haven't seen yet, okay?
Sure.
What's been going on with the exhibits? I know you've pre-marked a ton of exhibits, and I know Madam Court Reporter has been here all day marking exhibits, close to 600. It's too sloppy. We are going back to the old-fashioned way. Yesterday, the exhibits are available for the press on Tuesday and Thursday afternoons. That wonderful person from the clerk's office here that is doing that had the good sense to send it to me beforehand. And the exhibit number 140, the fire department report, when I reviewed it, I don't see these exhibits. Ordinarily, when exhibits are introduced into evidence, I get to see it. I have a copy of it. They are supposed to be held by the clerk and held overnight. I don't know where these exhibits are. And if there are 600 of them, they all need to be here.
Here's a hot take. If you have a message
Oh,
inside
Lord,
you that
more
people are meant to
commercials,
hear, it'll never make
and
the impact
means
that it truly deserves.
So we are going back to the old-fashioned way because on page 1 of 5 of what's been marked as Exhibit 160, and we are going to mark this for identification for these purposes.
That will be G for identification, Your Honor.
On page 1 of 5 is all of John O'Keefe's personal identifying information. That could have been on the front page of the Globe today.
It's not our exhibit.
It's got to be redacted. All exhibits have to be redacted before they are admitted into evidence. It may take a half a...
She's chastising the defense about these exhibits and that personal identifying information is not being redacted from the exhibits. The defense is saying these aren't even our exhibits. Like, this is the Commonwealth's exhibits. She continues on with, it has to be redacted. Like, she is refusing to direct her attention at the Commonwealth, who was the one that made the error. It's like ridiculous.
Day. We will break early if you need to do that, but they have to be cleared. In a case that doesn't have press interest, we let people do it maybe later that day or the next day. It has to be cleared. This never should have happened, Mr. Lally.
Yes.
So it's not going to happen.
Now,
all right?
finally,
so pre-marking exhibits is out. We are going to do it the old-fashioned way. If you're in agreement with exhibits, I still need to see them beforehand before they come in.
Sure.
You don't need to go authenticate everything if you're in agreement and it's obvious.
Got it.
And I don't need 100 pictures of snow. I'm just saying, all right, the jurors aren't going to look at 600 exhibits. I can't imagine that they won't, all right? So let's just move this case along. I'm not interfering with how you try the case, but I do have a role here, and these are important, all right? I was supposed to be gone.
She says, I am not interfering with the way that you try this case, but we need to move it along, okay? She says she's not wasting time. Y'all need to hurry up.
I was glad I was still here. This could have just gone out, okay?
Please apologize to Madam Court Reporter. I certainly did not mean to offend.
Nobody thinks you meant it, and I think it just underscores the point that the less unnecessary chatter, even during questions, the better.
Right.
There's less of a chance that this could just ask a question and no comment. Even the CPR, you not being certified except as we are not used to that here.
Right.
And I really don't want it.
Right.
Then
just because they're not used to something does not necessarily make it improper. Like, that is the thing that I focused on a lot during this trial. She was very bothered by the fact that the defense had a different style and a different way of doing things, and she was going to hammer them until they did it her way, for sure.
there is less chance of a problem.
Okay.
All right. Thank you. Okay, we will bring the witness in.
the closer in time you are to the event, the fresher your memory is going to be about the details of that event. You would agree with that, right?
Sure.
You told Trooper Proctor the day after the event, on January 30th, that the statement that you...
Okay, this is Katie McLaughlin. She was called to the scene on the day in question, and she is supposed to have overheard Karen Reed say, "I hit him, I hit him, I hit him." And so right now, what you are hearing is defense attorney Alan Jackson on his cross-examination of her.
attribute to my client was actually made to the female, not to you in response to your questioning. That's what you told Trooper Proctor, correct?
I don't have those notes in front of me, so I don't know that I can tell you that that's correct, but the statement was made in response to my question. However, the Miss Reed was looking at the civilian woman as she said that.
Does it refresh your recollection that what
Don't read what you think refreshes a recollection. You can show or you cannot read it. Yes.
take a look at the highlighted portion of that report and look up when you're finished.
Okay.
Ma'am?
Sure.
Yes.
Does that refresh your recollection about what you told Trooper Proctor on January 30th?
Yes.
And you told Trooper Proctor...
Let her... Hold on. I'll see it, son.
Sidebar.
How long is the statement? Does she need it in front of her?
No. It's just one sentence, Your Honor.
Okay, go ahead.
Thank you.
Why does she need to interrupt him for that?
Madam Your Honor?
Yes.
In fact, what you told Trooper Proctor was, quote, Karen then turned to her friend and stated, I hit him, I hit him, I hit him, I hit him. End quote. Correct?
Okay.
Is that yes?
Yes, if you're saying that's in quotation marks in that, then yes.
That's what's in the report.
Okay.
And I'm not, you don't have to agree with me. I'm asking yes or no questions. Not okay?
Yes.
Okay, thank you. So in fact, what you told Trooper Proctor was that Karen Reed looked at the female to your left and said 4 times, I hit him, I hit him, I hit him, I hit him. Correct?
Yes.
And have you since learned the name or identity of the female that was standing to your left?
No.
You're aware that the female that was standing to your left reported the exact same statement?
No.
Are you aware that the female standing to your left reported that exact same statement as, could I have hit him, did I hit him, did I hit him?
No, I'm not aware of that.
When the doors closed last time, people
He's
went
not
nuts.
aware of anything.
By popular demand, we are opening...
Put y'all on game.
Ms. McLaughlin, who's Caitlin Albert?
I went to high school with somebody named Caitlin Albert.
Y'all, this testimony is really important. She's saying she went to high school with someone named Caitlin Albert. Caitlin Albert is the daughter of the family who owned the home where Officer John O'Keefe's body was found. And she came to the scene, which is the home of Caitlin Albert. And she's saying, I went to school with somebody named Caitlin, as if she doesn't know Caitlin.
Somebody named Caitlin Albert.
I went to high school with somebody named Caitlin Albert.
So do you know Caitlin Albert?
I do.
You're friends with Caitlin Albert?
I would say more acquaintances, not close friends.
How do you describe an acquaintance?
I would say that we have mutual friends, so we might see each other occasionally because of mutual friends, but we don't have a one-on-one friendship or hang out regularly.
Who's her dad?
I don't know.
Do you know who her family is?
Jackson.
Sustained.
May we approach her?
Yes.
So why would he be objecting to whether or
What
not
is
she
the
knows
objection?
family?
Relevance.
How do you respond to that?
This witness has a deep friendship.
Okay, I'm pausing right here because he objected twice. She sustained the objection. She didn't even know what his legal reasoning for objecting, because she does not allow speaking objections. So you can object in her courtroom, but you are not allowed to say why you are objecting. So she sustained the objection without knowing the reason why he was objecting, and now she's asking, what's the reason?
With Caitlin Albert. She knows the Albert family. We have photographs of her traveling with Caitlin Albert, going to the beach with Caitlin Albert, going...
How old are those photographs?
I'd say probably they are adults. She's only mid-20s or so. I won't ask her age, but they can't be more than a couple of years old, 2 or 3 years old, I would guess. They have social media accounts with their friends. They tag each other. They vacation together. They drink together. They socialize together. She is diminishing the relationship between Caitlin Albert and her knowledge of the Albert family. I think she knows the Albert family. I know she knows the Albert family, and she knew where. The importance of 34 Fairview Road. I don't believe it's the first time she's ever been to 34 Fairview.
So you can focus on that. The other is too extreme. It's not relevant, and it's certainly not probative.
That she knows the family? Or
the house. You say it's relevant to the house, her being at the house.
How is it not relevant that this lady knows that family? And we're saying that you're framing my client. Like, how is that not relevant?
And she knows the family and she's been to the house. You can do that social media, traveling together. Is Caitlin Albert going to testify?
Yes.
She was just one of the people at the house that night?
Correct.
she was also at the Waterfall bar that night.
Yes, it's not probative. If any relevance, there's a little bit of a stretch too. But I'll let you get into that she knows her and she's been to that home before.
Just so we don't have to approach Sidebar again, I've got photographs of them together. May I mark those?
You can mark them for identification.
And show them to her?
No.
Your Honor, for the record, I have never seen any of this.
That's
I don't
Lally.
even know what counsel is talking about as far as photographs and social media.
But because it's impeachment.
But if you knew you were going to use it, you have an obligation.
I didn't know.
Hold on. Jurors, we are going to send you out. Mr. Court Officer, 10 minutes.
They send out the jury to continue this discussion.
All right. Ms. McLaughlin, I'm going to let you step out for a few minutes. Show them what you have.
Hey, Jen.
And let a court officer know when you're ready for me to come back out.
All right, to the court, please.
All right. So there was an objection that this was in violation of Rule 14 to admit these exhibits, Mr. Lally. That's what you said, correct?
Yes, sir.
Okay. So I agree. So the exhibits don't come in. But based on this voir dire and the answers, I'm going to give you some leeway on exactly what you did. Okay. The relationship, the social.
Okay, so right now what they're doing outside of the presence of the jury is voir diring this witness. Basically, they're going to ask some questions, some qualifying questions to see if he could dig more into the exhibits that he wanted to show to be able to really prove her to be the liar that she is. So they are doing this outside of the presence of the jury right now. Okay.
Socialization and the extent of it, friends on social media, those areas. You didn't quite get everything that you mentioned at Sidebar you thought you'd get. So that's not coming in.
So
If you
stay within the parameters.
So why don't you come over here then, just because?
Another sidebar. She said you didn't get everything you thought you was gonna get.
So you had said they'd been out drinking together and all of that. One person was holding a beer at a beach in a cropped photo. She's not at a bar room or anything.
No, I didn't suggest that they were in a bar room. That was what I was referring to. That they, I'm assuming that if Caitlin was drinking, she was drinking too.
You didn't get it from them, so you can't do that.
I'd forgotten to, and I should do it here at Sidebar. I had forgotten to actually refer to the third photograph. Is it J, K? No.
That's the sound of an American oil company hard at work. Want to be a part of it? Listen up.
Hello.
I wonder how
Jay.
you those.
May I have those, please? Those photographs?
I think it's this one. That one. I forgot to mention that this was
These
K.
are Karen Reed's
That it's been
parents
marked.
that they're showing right now.
Okay.
Mother and father.
They look like young girls in bathing suits.
I do want to make a record that I disagree with the Commonwealth in terms of the Rule 14 objection. The reason that we disagree, this is pure impeachment. As the court well knows, this is not something that we are going to use in the case in chief. Indeed, I was never, and I can show the Commonwealth and I can show the court. My order of proof in terms of my outline, I literally do not bring up photos unless ... she denied the relationship or she was trying to distance herself from the relationship. I think that's obviously some level of deceit on her part. She knew that there was a relationship. I can prove that there was a relationship with these photos. The level of the relationship is up to the jurors to decide. But she said, her first answer, Your Honor, was I said, who is Caitlin Albert? And I just left it open for her to say, she's a friend of mine. She's an acquaintance. We went to high school together, and I've known her for 10 years. And she said none of that. What she said is, there was a girl in high school with that name, and that's a lie. And that is why we are, and now she's changing that story. Because I am about to impeach her with those photographs, I don't think that that's a violation of Rule 14. This is pure impeachment.
Mr. Lally?
What I'd say is I don't think that that is a lie. I think that's exactly what was borne on her testimony in voir dire. The last thing I would say, just to flag for the court, is this is a witness who has been harassed by Mr. Kearney on this specific...
Mr. Who?
Mr. Kearney, on this specific issue. So if we are going down this road as far as impeachment is concerned, I intend to get into that.
Come to Sidebar before you do. So I find that it is a violation of Rule 14. So these photographs won't come in. We will keep them handy in case you need to refresh your recollection. They are not to be shown on the screen.
Okay, so Rule 14 is like a discovery violation. Basically, they haven't disclosed that they're going to use this material. He's saying, I never planned to use the material unless she lied. And she lied. And so now I'm trying to impeach her testimony. So I should be allowed to use these photos. Judge Cannone has used every excuse not to be able to use these photos. First, she said it looked like they young girls, like as if it's like some violation because they're too young. Then it's like, oh, they ain't even at a bar. You said they was at a bar. He said, I never said they were at a bar. I said that they were out drinking together. And if somebody's in the picture with a beer in their hand, then they're drinking together. And so now it's a Rule 14 violation. You always knew you was going to use these photos.
Understood.
I expect that the press will not see these photographs.
No. Of course not.
She doesn't want anybody
Of course
to
not.
see it because
They've seen all sorts of things. I was told this morning that one of these photographs has already been circulating today.
Not from us. Not from us.
I'm just saying, but when you said, of course not, I have to be concerned about these things.
I understand. I just don't want the court to cast a dispersion on us that we were out there leaking stuff. We were not.
No, I'm not saying that.
Yes,
We don't play those games. Am I allowed to refer to the photo, just not show them? In other words, what is this a photo of? Does it appear to you to be a photo taken with Caitlin?
No, you can talk to her about her relationship. I think she will tell you she was at a beach.
Okay.
You can talk, and if she doesn't,
tell you that?
you can show her.
Lied.
Okay. I just want to make sure I'm clear. I don't want to overstep. Can I ask, have you ever been photographed socializing with anyone?
Sure.
Okay. I think I'll get the answer, and then I won't have to show it. Okay?
All right. All right. Let's bring in the jurors.
This is the year you stop posting on social media manually because AI now does it better.
Basically, what's happening right now is they're at a sidebar. He's trying to introduce these photos into evidence. The judge is saying that he cannot. He's like, can I refer to the photo? She said, no. You could ask her if she went to the beach. He said, so that's basically what's happening, right? He's trying to be able to show these photos, and the judge is saying, no. He probably wanted to be able to show the photos as like shock value, right? You said you ain't know these people. Ha! Caught you in a lie. But she's watering down how much he can get into this. Hey, Trent, happy Saturday.
You're asking if I know from
between those two dates.
Right.
Yes.
Between the time you spoke with
Yes.
Proctor in this report till yesterday when you testified, you now know that that's the Albert home.
Yes.
And you also indicated that between that report that you gave to Trooper Proctor, that statement that you gave to Trooper Proctor, and yesterday's testimony, your statement has evolved. You've already admitted that, correct?
I don't think I agreed with you on that.
It's changed. It's different.
I've always testified to I feel as though my testimony has been consistent.
I appreciate how you might feel. I'm just interested in the actual facts. You didn't tell Trooper Proctor anything about this officer questioning my client. Correct?
Objection.
So I'm going to see counsel at sidebar because I think this morphed into a different.
Sidebar again. Tone.
So are you objecting to the
Tone, I agree and I disagree, because sometimes the defense does hold certain things, and he's saying, well, I hoped she would be honest, because after all, aren't you supposed to be honest on the stand when you go in there and raise your right hand and swear before God and the law that you're going to be honest? And so he's saying, I thought I was giving the lady the benefit of the doubt. I thought she was going to be honest, but she's a liar. Okay.
argumentative nature that the question began with?
Yes.
Okay. You can't do that with all the evolving. The Commonwealth didn't object until now. But now that they have objected, the argumentative nature of some of these questions, the objection is sustained. But you changed it into impeaching her with a prior statement, correct? Okay. So if there's continued objections about the argumentative nature, it will be sustained. If it's strict impeachment, you have to ask the question again.
I'll rephrase it.
It's lawyering. It's going to be argumentative. This is gross.
You agree, Mr. McLaughlin, that the statement that you gave to Trooper Proctor is not the same as the statement that you gave to these jurors yesterday, correct?
Yes.
I just want to know.
Yes.
So he just got her
With
to
respect
admit
to, you went to
that the statement that she gave yesterday to the jury and the statement that she gave 2 days after the incident were two different statements, which basically means she's a liar.
you say high school, you graduated from Canton High School, correct?
Correct.
This is Commonwealth's attorney Lowley, who is doing redirect right now. So he's going back and asking her like follow-up questions to kind of clean up the lies she done told.
You grew up in Canton, is that correct?
Yes.
And did you know Caitlin Albert before you attended Canton High School?
No, that's probably when we first really interacted with high school.
And essentially, you live within the town I'm sorry, you work within the town that you grew up, correct?
Correct.
And is that abnormal from a civil service perspective?
No, from a civil service perspective, you're given more points for residency, so it's actually, I would say, preferred, or you're placed higher on the list if you have residency in that town.
So it's actually preferred and more common than uncommon as far as growing up in a town and then working in that same town in a civil service position like a firefighter.
Yes.
Now, during the course of the time that you've been on the Canton Fire Department, have you received calls to residencies or other places or even patients that you either knew or were familiar with?
Yes.
Would that be a reason for you to not go on a call?
No.
And you have an obligation, wouldn't you say, to respond to a call when a call is made and you're on duty in that station house, correct?
Yes.
The objection sustained. Ask the question differently.
As far as when you're on duty as a firefighter at a particular station house and you get a call, what, if any, choice do you have to respond to any particular call?
I don't have a choice. I just have to respond to the call.
And then prior to that date of January 29th, had you ever been over through socialization or otherwise Caitlin Albert's house?
Not that I ever remember.
Had she ever been over your house?
No.
And again, had you ever socialized with her outside of a large group of people?
No.
When you responded on that morning, just after 6 a.m., the house of 34 Fairview Road, did you know who lived there?
No.
During the time since January 29th of 2022, have you ever spoken to Caitlin Albert about what happened that morning in front of 34 Fairview Road?
No.
Now, you were asked some questions on cross-examination about knowing sort of Caitlin Albert's parents' names or siblings' names or things of that, correct?
Right.
And prior to January 29th, you didn't know any of those names, is that correct?
No.
You learned of them subsequently, is that correct?
Yes.
May we approach just briefly?
Okay.
Child, you mean to tell me you hanging out with these people all the time and not one time did this lady say, my brother such and such, my mom and dad, like, it's a small town. Everybody literally knows everybody. There is no way she didn't know these people's names. It's absolutely no way. It's no way she didn't know that was their home, even if she never been there, because they lived there their whole life. I think they lived in that house for like 30 years and they sold it because of this trial.
You, just you, building your app. on base 44.
So my next question is how she knows. And then this sort of gets into that area of not only Mr. Kearney, but this witness also had a visit from a defense investigator in which the defendant was in the car parked outside of her house at that time, that defense investigator sort of pushed his way into the home with her parents to try to speak to her at one point during the pendency of this case.
Your Honor, that is not true. First of all, there is no male defense investigator who has ever approached her. We did actually have an investigator, a female, knock on the door, have a very polite conversation with the McLaughlin parents, who said she would rather not speak with us, and we left, which is our obligation and well within our... Actually, it would be.
I understand.
So nobody tried to push their way in. I don't know where Mr. Lally is getting this other than the witness, and she wasn't even there. We never made contact.
So I guess I'm a little confused as to you said your next question is going to be what?
How she became aware of those names after the fact.
I thought she testified she saw it on the news.
That's what she did say.
Again, I don't know that the news is necessarily Channel 5, Channel 4, or things of that nature.
You brought it up. I'm going to let you lead through whether... What do you suggest, Mr. Jackson?
I don't think this has any. If this is the Commonwealth's way of trying to sully the defendant,
No, I'm asking for suggestions on how you brought it up about she learned these names, knows these names.
She's testified to it, and the fact that she watched the news.
That was on voir dire.
And I think he should be able to lead her and say,
well, that's why I asked for suggestions.
Is it true that you learned this on the news? That was your testimony. And leave it at that.
I'm not going to let you get into the Kearney stuff through this witness. There may be other witnesses, but not this witness.
Okay, so I'm gonna pause right here. We're almost done with this first video. I think we have 2 more minutes, but I'm pausing because they're talking about Aiden Kearney. Aiden Kearney has a channel called The Turtle Boy. Turtle Boy lives in this town, has done extensive investigation of this particular case. He got really involved. He contacted witnesses or potential witnesses, law enforcement. He dug into their backgrounds. He posted things. And that he had a subsequent trial where they were basically trying him for witness tampering, witness intimidation. They were trying to lump Karen into that to say that they were working in cahoots together to basically scare off the witnesses. He still has some pending litigation, but he's won some of those things and had some things dismissed. So Aiden Kearney, that's who they're talking about. This guy who's just like me, just like you, who was very interested in this trial, believed that they were railroading Karen, and he really dug into it. And honestly, she probably won this trial because of his work and work of other creators that really got into this case.
You can lead her what she learned by the news broadcast. If it was social media news, that's fine.
Understood.
So, Ms. McLaughlin, you learned of other people's names within the Albert family subsequent to your response to this call on January 29th. Is that correct?
Yes.
And you learned of those through sort of various news or media reports in relation to this case, not something that you had any conversations with anybody about, correct?
Correct.
I have nothing further.
All right.
Your Honor, if I may, I have
Okay. Okay.
you indicated, Ms. McLaughlin, Mr. Lally just asked you about these 500 friends on social media. A couple of quick questions about that. Of those 500 friends on social media, how many of those have you taken day trips with?
I don't know.
How many of those have you gone to the beach with?
I don't know.
How many of those have you posed for photographs with?
I don't know.
How many of those have you posed for photographs in swimwear with?
I don't know.
How many of those have you been photographed with your arm around while that other friend is drinking a beer?
Sustained. Sustained.
Ms. McLaughlin, all of those things that I just mentioned, you have done with this Caitlin Albert.
Objection, Your Honor.
Sustained.
That's all I have.
Okay. All right, Firefighter McLaughlin, you are all set.
Oh,
Goodbye. Pen work should be reduced.
Okay. We're gonna move
I don't like
on
homework.
So, ladies and gentlemen, as Her Honor just described, we're about to go to a place. When we arrive there, and at any point in time when we're there, this is not a point where we can have any sort of conversation or back and forth. So, all I'm going to be asking you to do is just take note of certain locations and certain items as you see them. And again, as with anything in this case, this is as you find them, as you observe them. Okay? So first I'm going to ask you to sort of, when we arrive in a general area, as far as taking note of sort of street names when you're coming into and when you're exiting from this particular area. When we arrive at a specific location, I'm going to ask you to take note of certain things about the roadway. Okay? Certain
Look at his hair. Tone. This judge was off the chain. I have watched many trials. The only other judge that I felt like so far has even come close to this type of behavior was the judge in the Alicia Andrews trial. And in fact, Alicia right now is appealing her trial based off of the things that the judge did, and is asking for the judge to be removed. She was supposed to be sentenced December the 8th, but the judge could not go forward with the sentencing because they submitted a motion to have her removed. And so we're just waiting right now for a decision on that. But this judge, I never seen anything like it before.
certainly any abutments to the roadway, any residences that you observe, the distances between the roadway, and any landmarks or any items that you observe on that property, specifically a driveway, specifically a front door, any other sort of items of interest within the front lawn area of that home. I'm also going to ask you to take note of the roadway itself and sort of the width of that roadway, whether or not you find any sort of lanes separating within that roadway, and then the individual width of some of those lanes as well. Lastly, there is also going to be a vehicle there as well, and I'm going to ask you to take note of certain things with respect to that vehicle, okay? With respect to the size of the vehicle, with respect to the height of the vehicle, with respect to anything that you observe specifically from the front, the side, the back, all of the exterior of that vehicle, and then also some of the interior of that vehicle. And specifically, I'm going to ask you to take note of sort of the center console in the front driver's compartment of that vehicle, and anything that you observe in that location as well. And that is all I'm asking you to do in this case, and I thank you again for your time and attention.
All right, Mr. Jackson.
Thank you, ladies and gentlemen. It's the first time we've been able to speak to you directly, so I want to take the opportunity to introduce myself and thank you for your service and thank you for your time and commitment to this. I'm going to echo a lot of what Mr. Lally just said. There's nothing magical about this other than it gives you perspective. It's an opportunity to introduce you in three-dimensional form to stuff that you've been seeing in two-dimensional form. Photographs, some of the testimony, diagrams that you might see.
So I'm sorry, we're really pointed on what you can say.
What we're going to ask you to do is take special note of the relationships of physical items out at the scene. Much as Mr. Lally just indicated, there are going to be physical things out at the scene. You've heard about a flagpole, a fire hydrant, a house. We're going to ask you to take special note of where those are in relation to other things physically at the scene. That will hopefully, with the court's instruction, give you some assistance in putting together the testimony that you think is relevant, the documents that you think are relevant. Again, to echo what Mr. Lally said, we're going to ask you to look at the roadway, the vehicle, the house, the physical items at the home, and the relationship between and among all of those things to each other. Hopefully, that will give you a very good understanding of what we're dealing with, especially with the exhibits. Thank you.
All right, so folks, we'll be all set. We'll see you at the bus in a little bit.
Make sure you don't put yourself closed.
You are muted.
Goodbye.
Simple. I only pay $10 a month for my internet connection. Fast, unlimited, anywhere.
Have you heard about Ryoko Pro?
Good morning again, ladies and gentlemen. Again, as I stated in the courtroom, this is my opportunity to address you here. So some of the things that we talked about in there is what I would direct your attention to now.
So all we're going to get are still photos right now, because otherwise we would see video of the jurors, and you know that we cannot see video of the jurors. But what you are seeing right now is the home, the yard. That is Karen Reed's Lexus that they claim is the weapon that was used in this unaliving. And so they just brought supposedly they brought the vehicle here just so that they could see up close the car, the damage to the car, and size to scale to have a visual of the size of the vehicle in relation to the injuries or no injuries that John O'Keefe had sustained. But this is the home, and they're going to talk more about that. Look at the fact that there are 3 different doors to lead into this home. One on the side of the garage, which is kind of red. One right next to it that has these couple of little stairs with the white picket fence, and then one directly in the center of the house. So those things are important. Pay attention. I'm going to go.
So you find yourself standing in a roadway. I would ask you to take note sort of that roadway, of its length, both as you came in and as you exit at the close of all this. But also I would ask you to take note of just the condition of that roadway, the width of that roadway. What, if anything, you observe as far as lanes within that roadway, both in the middle and sort of towards the side of the roadway? I would ask you to take note in different areas as far as where that roadway ends and where sort of other properties or residences begin, where you find that to be, and specifically as it pertains to a residence to your right. I would ask you to take note of distances from areas as far as where we're standing now to where the driveway is, where we're standing now to where the house is, any doors or entrances, exits that you observe from that house, as well as anything else that you note as far as a landmark for some sort of tangible objects that you observe within, specifically the front area of the home and specifically the front to the left as you're facing the house, in that area of the front lawn yard area of the home. Thank you.
Hi, ladies and gentlemen. Again, I would echo a lot of what Mr. Lally just said. We just want you to get comfortable with the area surrounding the house, the roadway, the width of the roadway. I also want you to pay special attention, if you wouldn't mind, and note an area to the right of the flagpole. Its relationship to the fence, the gate, its relationship to a front door that appears in the middle of the house and another door that appears just to the left. I would also ask that you pay special attention, if you can, to the area of the driveway and what ingress and egress, entrance and exits would look like at the front of the house, as well as any obstructions between those areas and the area adjacent to the flagpole here. I would also ask you to take some note of the roadway and whether or not it's perfectly straight, whether or not you see a curvature in the roadway, the width of the roadway, both from curb to curb, as well as the width of the roadway from the center line to curb. things of that nature. The last thing I'd ask you to pay attention to is simply the length of the area from the mailbox, all the way up to an area. It would be close to the natural property line, maybe here or beyond. The length as it pertains to vehicular traffic that may be parked. And that's about it. I think with that would satisfy us. Thank you, Your Honor. Oh, Your Honor, there is one other thing. There are a series of windows, both on the bottom floor and the top floor. I would ask you to pay special attention to the window on the top left of the home and its relationship to where you're standing, as well as the property area in front as well. Thank you, Your Honor.
Okay, the reason why he asked them to pay attention to the top left window, that is the window of the owner's suite, the master bedroom, and it is very close to where the flagpole is. The flagpole is just outside of you. So where you see the white fence, up closer to the street, like in the middle of the yardway, straight from that fence out is where the flagpole was, which is approximately where Mr. O'Keefe's body was found. And when all of this was going on, police, lights, sirens, EMTs, ambulance, all of this is going on. They're doing life-saving measures, giving CPR. Karen is screaming and crying and being hysterical and running around. All of this is going on. And the homeowner, who is a Boston police officer, or was, he's retired now, he never came out of his house, not once. He said he was sleeping. He didn't hear any of this. Tone, are you still here? Because I want to know, as a cop, as a former police officer, if all of that was going on right under your window, would you have heard it?
Some moms want to build income from home. They just don't want to
almost
post,
anybody
pitch, or
would,
be
but I
online
would
all
think
the time.
a law enforcement person would definitely.
Your Honor, with the court's permission, what I would ask is just to give them a few minutes to do that, then take them over to the vehicle. Mr. Jackson pointed out that he would like to see inside the vehicle. It's been a while since I've...
Open the door and see inside?
Yes,
ma'am.
just to look prior to the jury going over there. So with the court's permission, that's what we would...
Sure. Where you ask them to look at the driveway, why don't we go beyond the car first to the driveway and then walk back to the car?
They can't see the mailbox.
So, well, if we can tell them that we'll walk past the car to the driveway and then come back to the car.
Okay, we can do that. So, ladies and gentlemen, I by no way mean, shape, or form mean to cut you short if you're still making observations.
Okay, y'all see the flagpole right now. You can see the flagpole in relation to where the street is. Nobody knows exactly where his body was because they didn't take any pictures. Nope, they didn't take no pictures of nothing. So who knows? It's about right here, somewhere, they say. Nobody knows for sure.
Or looking at things. But at this point, what I'm going to ask is for us to make our way down to the driveway just beyond the vehicle on the road. And then we'll make our way back to the vehicle after we've gone over to that area, okay? So again, ladies and gentlemen, in this particular area, the same sort of general observations that I referenced before. The only other thing that I would add to that is I would ask that you take note of sort of...
Okay, one quick second, another interruption, sorry. So this is exactly how the home looked before they sold it, okay? When you see the blue pictures of the house, that's after they sold the home. They changed the flooring in the house, fresh coats of paint, all the things, and sold the house before the first trial. And they also got rid of their dog. They got rid of their dog Chloe also before the first trial. Nobody knows where Chloe is.
Again, where you find these things to be, but where you find sort of property lines to begin and property lines to end. Sort of any natural observations that you make in reference to that structure, things of that nature, as well as similar to when we were on the other side of the property, now being sort of to the right as facing the residence as you walk, any sort of, man-made structures or landmarks, if you will, that you observe within and around sort of the yard area as well as the driveway area.
Inside the vehicle, counsel noted that there is a search warrant and business card of one of the troopers. We are going inside the vehicle to remove the search warrant and any law enforcement identification cards.
They should be marked or ID.
So the Commonwealth will take possession of this right now. Did you bring stickers?
No. But, that will be L for identification.
Okay. If I could do just a cursory look.
Of course.
All right, so Ms. McLaughlin, I'll take that. So this is Madam Court Reporters. I am going to put that on there. So, do you want to close these doors and then open them for them? Explain to them? Mr. Jackson, it's your request that we look in the car.
It's Mr. Lally's request, but I have no objection.
All right, so why don't you just tell them what we are going to do?
Running a business is hard enough. So why does managing your social media have to feel like a second job? It did for me.
So ladies and gentlemen, if you want to just come in a little bit so I'm not screaming as much, again, not to cut you short in any respect whatsoever as to any observations that you make or want to make with reference to this area of the house or the one previous. So what I'm going to direct your attention or ask you to note at this point is with respect to a vehicle that is parked on the roadway behind you, okay? What I'm going to ask you to take note of with respect to that is, again, as I stated in the courtroom, the height of that vehicle, the width of that vehicle, the overall shape and size of that vehicle. In particular, I'm going to ask you to sort of walk around the exterior, paying close attention to sort of the height and width as you go around the vehicle. What I'm also going to ask the court officer to do.
I'm asking y'all to pay attention to this evidence too. Do you see the damage to the tail light and basically nothing else on this vehicle?
Do is open up the front door of that vehicle so that you can make observations of the driver's compartment of that vehicle, and in particular anything that you may note sort of on the dashboard in between the driver's seat and the passenger seat. Okay, thank you.
Do more than knock out.
Very briefly, also to dovetail into what Mr. Lally just suggested, the height, the width of the vehicle is obviously important, and I would ask you to take note of the rear end of the vehicle, the bumper area, and the height specifically of the taillight area on the vehicle as well, when you're taking a look at the rest of the car. That's it.
Anything else from the defense?
No, Your Honor.
Anything else from the Commonwealth?
No, Your Honor.
Can I see counsel, please? How long are we going to stay?
I mean, I'm fine, but I don't want to interrupt them or...
I don't want to interrupt them either.
Seems like at least a couple are still considering things.
I would say probably 5-10 minutes or so at the most. That should cover it.
I think as long as we stand here, they are going to stay here.
Baby, she be wanting to hurry up and be done. She said, how long we gonna be here? Get these people together. I'm ready to go.
That's the other thing.
But if you want, signal me when we should wrap it up, and I'll start walking.
About 10 minutes.
The chief court officer said one particular juror wanted to know how far up the driveway she could go.
I'm in touch with the homeowner. They gave us permission to go on the property. I can call and ask if a juror could go on the property if nobody objects.
I wish we had known that before.
I didn't expect that we'd go on the property.
I think we said nobody could go on the property when we started all this.
I think it's safer to just go with that. Open it up on one end, and then somebody else wants to do something else. Then they want to go in the house.
That's why I asked you all to work together on the view.
We did.
Okay? There is no question or answer. What does counsel suggest?
Our suggestion would be to tell the jurors you're going to determine, based on the testimony, where the car was or wasn't.
Okay, so they're technically not supposed to answer jury questions right now anyway. So they're now determining how they should respond to this question of where was the vehicle positioned on the night in question.
It's here more for exhibit than specificity of it's placed randomly right now, correct? I think that would be the answer. They will just have to wait on who testifies to where they saw it.
I prefer not to comment at all on the evidence. We are here to stop and look. Those were my instructions. You're merely here to look.
I have no problem with that, as long as they don't think it's specifically placed, because
So she doesn't want to answer the question at all. She just want to leave it open and let their minds wander and let them believe that that's where the hell the damn car was parked at. Listen, she could just simply say what they said. It's just parked randomly right now. It's just for your viewing. She said she don't want to say nothing. Yeah.
it's not. That was the question.
I don't want to field questions because if there's one, there could be 15, and that's not the purpose of the view. What is the Commonwealth's position?
I would just suggest what you propose, perhaps with a limiting instruction as to they are the fact finders, and they assess the weight and credibility through the evidence that will come out at trial.
I don't think there's any evidence to be evaluated with credibility when it's really the opposite.
What I am inclined to say is that the purpose of a view is for you folks to stop and look and observe what you're seeing, and you can use this as evidence in your deliberations. Just sort of what I said before. I think I'm inclined to also say no one can answer questions. Do you want the question part or no?
I would like you to say we are not allowed to answer questions.
I think that's good.
Okay.
We will bring them together behind the car, Your Honor?
Sure.
Behind the car so they can keep looking at that crack.
So, folks, the purpose of a view, as I told you before, first of all, the view is evidence. But what you are to do while we are here is to stop, look, observe your surroundings, and then later you can use this in your deliberations. It's not a time for questions or answers. I can't let you ask questions of counsel, and I can't answer any questions. So that is simply the purpose, and we appreciate how close attention you all are paying to this. Thank you. Counsel, please. Do you think we should wrap it up?
Sure. Maybe ask them if there's any objection if we leave?
I've never done that before. We decide when it's time. Jurors don't object. I'm not inclined to do that. I will give them another few minutes. I think you are very fortunate that they are paying such close attention.
Yes.
Actually, counsel, it occurs to me that one of the jurors is pacing and measuring out pacing. It should have occurred to me earlier. They are also told that they are not to investigate, and that's pretty much investigation, so we're going to wrap it up.
All right, folks. We are going to head back to the bus.
Look at the bus.
Brian is the best content marketing team lead I've ever worked with, but before he created his content calendar using Monday.com.
As far as the information that Firefighter McLaughlin provided,
real quick before we get to this testimony, I want to talk about these two things right here. Pitt says, how crime scene got 0 pics of the body. And I just want to point out that this happened in a small town of Canton. Canton, they were not used to and or equipped to handle a crime like this. The crime scene, none of it. And Boston PD did eventually, Massachusetts State Police actually did come in and take over this investigation because they were not equipped to handle it. So they made a lot of mistakes in the beginning of this case. And then Massachusetts former state trooper, Michael Proctor, decided on day one, we're going to pin it on the girl. And they just made the evidence fit that. So that's how. And the other question, all the things to conceal blood evidence. I don't even know if they were trying to conceal blood evidence because they collected the blood in the snow in red Solo cups. I never heard of such. In red Solo cups, they collected that evidence. You know that thing is contaminated. It wasn't covered or nothing. They put the red Solo cups down inside a brown paper bag that they got out of somebody's house. It wasn't an evidence bag, that's free from contamination. It was an old grocery bag out of somebody's house that lived across the street. That's what they did. That's how jacked up this stuff was. So, yeah. Barney Fife knows to take pictures. Oh my goodness.
Does that comport with what you were observing as far as injuries to Mr. O'Keefe?
Objection. Sustained. Can lay a foundation.
Now,
so the defense objects. She sustains the objection, but then she helps the Commonwealth on how he can get in the testimony he wants. That she is not supposed to be teaching during the trial. I don't know what is going on here.
As far as, again, the injuries that you observed to Mr. O'Keefe in the back of the ambulance were what?
It was the bruising of the right eye and the scratches on the forearm.
And what, if anything, did firefighter McLaughlin indicate to you what had been told to her?
That someone said she had hit him, and he was last seen.
Objection.
Sustained. That will be stricken. Okay.
Sidebar.
So it's hearsay, but it's not for the truth of the matter asserted, Your Honor. But the state of mind of this witness, as far as his treatment and diagnosis, as far as receiving the information, not in conformity with what he's observing on the patient, and then seeking more information.
So you have to lay a foundation for that.
I think I did as far as what his observations were.
Not sufficient.
If I don't have the statement, I can't ask him if it comports with what he's observed.
What do you say, Mr. Yannetti?
Well, first of all, I have a question on the relevance of his state of mind as it pertains to the issues in this trial. And, I think it's just a backdoor way to get in some type of hearsay corroboration of Miss McLaughlin's testimony.
Corroboration? The jury has already heard from Miss McLaughlin as to what the statements were. We've also already heard those statements as related by 2 other witnesses separately.
So, what is it exactly? It's a good time for a lunch break. What is it exactly that you want to ask him?
I want to ask him what he was told as far as what firefighter McLaughlin learned from this person.
And why do you say that's not hearsay?
Again, the follow-up question that I'd like to ask about is whether or not that explained to him what the injuries were that he observed, were purportedly what he was observing.
For what purpose, though?
Again, I think it goes to his treatment in relation to Mr. O'Keefe and how that was handled.
What do you say, Mr. Yannetti?
Well, I say that, we haven't received any notice that this witness would be offered as an expert witness. I think there has been lack of foundation in terms of his qualification to give an opinion of the status of the injuries and whether they comport with what he's viewing. He's not an expert pathologist, or he hasn't been qualified in any way. So I would object on that basis as well.
Isn't this what you all put in through another paramedic? That I did tell Mr. Jackson he needed to lay a different foundation. All right, we will take a lunch recess. When we come back, you can argue it to me.
As we always try to check and make sure that your lunch is here before we take a break. I'm told that it is. So we will take a lunch break. We'll see everybody here ready to start right at 2 o'clock.
She loved her breaks. Daggone it. And it's so convenient to take a lunch break when the Commonwealth is struggling, to give them a chance to think about what they need to do and how to regroup.
If you're a Christian thinking about starting a franchise business, don't. I'm Douglas James, and just imagine.
That's one of them, yes.
Hysterical at times?
Yes.
Raising her voice at times?
Yes.
Crying at times?
I didn't see any actual tears, but
This is David Yannetti for the defense on cross-examination right now.
That type of emotional display.
All right. And so in terms of the only commentary that you heard with regard to her feelings or questions regarding John O'Keefe, it was the statements that you heard repetitively over and over and over again. Is he dead? Is he dead? Is he dead? Is he dead?
That was some of the things she was saying, yes.
Your Honor, may we approach sidebar briefly?
Sidebar.
My next and final line of cross-examination will be with regard to the injuries to his arm that this witness testified about. And the reason I'm approaching sidebar is I would like to show him the autopsy photo that the court has previously seen, which depicts the injuries that he's described. Given the sensitive nature of it, I didn't want to display that in open court without getting the court's permission first.
What does the Commonwealth say?
As far as that photograph, I would anticipate something along...
Speak up.
I'm sorry. I would anticipate something along the same lines that I would be seeking to introduce at a later time.
Is this what he saw, though, in that short time in the ambulance?
That I don't know.
Well, he saw those injuries, whether they had more blood on them or not.
These are obviously going to come into evidence.
They are.
I'm just not sure this is the right witness.
Well, I want to explore that, Judge. And if I fail to lay a foundation, I will mark them for ID, but I want to show it to him to see if he will identify.
Why do you need 3?
I don't.
Okay. I am going to mark 1 for identification now. If he adopts it, you can put it in through him.
Great.
If he doesn't adopt it, you can't.
I understand.
Mr. Jackson, please come back.
What is the letter for ID?
That will be N for ID.
Thank you. Do you intend to put it up on the screen afterwards?
I would. Yes.
All right. So get him to adopt it.
Yes.
Why should you make Mr. Jackson come back? He wasn't even the one asking the questions.
So I think, Ms. Tianetti, I think you need the actual...
Yes. I was going to ask a couple of questions first and then grab it.
But it's right there for when you need it.
Lieutenant Woodbury, on your direct examination, you testified a bit, and I don't want to block a jury here, I'm sorry. You testified a bit about the injuries that you observed on John O'Keefe when you first arrived at the scene, correct?
Yes.
You testified about the swollen eye,
Yes.
and you also testified about the scratch marks that you saw on his forearm, correct?
Correct.
I'd like to show you, I'm going to approach in a minute, to show you what has been marked M for identification. And when I hand it to you, please keep it to yourself and look at it, and then look up at me when you're done, okay? Having reviewed M for identification, do you recognize what that depicts?
Yes.
What does it depict?
That is Mr. O'Keefe's right arm.
Does that photograph appear to be a fair and accurate representation of the scratch marks that you observed on January 29th of 2022, sir?
Yes.
I would offer that, Your Honor.
Okay. That will be our next exhibit, and again, we'll have to maybe renumber. Counsel, before you leave today, we have to figure out how to keep everything straight.
Understood.
You should be figuring that out. You and your...
And with the court's permission, Your Honor, may I have that published on the screen for the jury?
Yes.
You and Nancy. We can't call Nancy, Madam Court Reporter.
Now, on direct examination, Lieutenant, hang on. Let me just have a moment.
Okay, these are the injuries to John O'Keefe's arm. Okay, these are the injuries that the Commonwealth are calling cuts and saying that it happened from the tail light. The defense is saying these look like animal bites and or claw marks. And if you look like right where the elbow is, if that arm was bent, you can tell that it looks like teeth marks. But yeah, they said it was from the broken tail light. That's what they said.
Oh, good point. I'm going to try to get out of your way. With regard to the injuries that you described on direct examination, Lieutenant, I believe you would mainly concentrate...
I'm sorry, I need to... Please take this down for me.
So they're going to take it down because you can see some of his body in that picture, and they don't want to show that part to the...
What I hadn't noticed quite as clearly is the body shows up tremendously on the screen. And we've got a photographer over there aiming his camera at it.
I see.
You've got your IT guy. Can you block that out?
Yes. We'll do that right now. Can we have 30 seconds?
Yes. So we can take the photo.
It's electronic.
I understand that, but just so you know exactly where. Just the arm.
Just show that to him. Just show him what needs to be cropped off.
Okay, so since they're cropping this, I want to tell you guys that that in the background where you see his body, it kind of looks bruised, but that is not any bruising that came from this alleged incident or accident. That is just lividity from his body, you know, after he passed, and the blood flow going to the back because he was laying on his back. So that is what that's what you're seeing, not bruising. We're in recess because it took longer than 30 seconds to crop.
Imagine being able to build anything just by thinking about it. Meet Base 44,
How you find out
a complete AI creation platform made for anyone with an idea.
This court is in session. Please be seated.
So, jurors, I can assure you that by Monday, I mean, we're in really good shape. It's an organizational situation that I have to deal with. So we've been dealing with that. We appreciate your patience, and we are in good shape. And Ms. Giannetti, if you need the exhibit, it's here.
Terrific. May I have it published again on the camera?
Yes.
Now, Lieutenant, with regard to the injuries that you observed, did you notice any lividity on the body when you were looking at Cannone?
Being hypothermic, he was very pale overall. So the skin wasn't pinked up yet. So it's hard to really judge the rest of the skin that way until it's warmed up and much later into the scene.
You are familiar with the term?
Yep. Yes.
Could you just explain that for the jury?
That's like bruising. So the pooling of blood in lower sections. So for like a cardiac arrest patient, when they have lividity, it looks like bruising on the underside where all the blood has pooled. And we did not really notice that.
But it's not actually bruising from an injury, it's just the blood
settling down. It's the same thing, yes.
One at a time, please.
Yeah, sorry. It appears like bruising, and bruising is basically pooling of blood under the skin. So lividity is just gravity-fed pooling of blood under the skin. And it usually happens what is the section of the body that is lowest.
I see. Okay. Now, with regard to the scratches that you've testified about and that you now observe on Exhibit 382, I believe, and you'll correct me if I'm wrong, but I believe your testimony on direct examination was that you observed them in the forearm area, correct?
It was the right, forearm to arm. I was trying to signal, right up here, but yeah.
Oh, okay. All right.
Yeah.
That's not.
Yeah.
It wasn't just on the
Not just, it was the arm area. Mostly what I noticed was forearm, but they were.
We're deep into overtime. If you guys can still ride it out with me, let me know. If we need to stop and pick back up next Saturday, you guys let me know in the comments how you want to do it.
Some around there.
Okay, so it wasn't just below the elbow?
It was not just below the elbow.
There was some above the elbow as well?
Yep.
That's consistent with Exhibit 382?
Correct.
27mm?
Yes.
No further questions.
Mr. Lally, anything further?
No, Your Honor.
All right, Lieutenant, thank you very much. So you're all set.
How many documents is that to review that look up?
The first report up here is the engines. Second one would be mine.
Do you recognize the first few pages of that as the engines report and the last few are yours, right?
Correct.
And that's your report
There's
with
about
relation to
15
this
more
dispatch.
minutes left in the
Correct.
video, so
Coach Daniel?
Yes.
I want to see you introduce in a minute.
So both reports for this witness? Is there any objection?
Yeah, just take a look at the DA's copy. Where we approach?
Okay.
Your Honor, my only issue is that he has testified that the engine report is not his. He did not write it. So there is no authentication for that. I would not object to his own report going in.
It is the same that you gave the last witness.
Only to refresh memory.
I understand. I don't think anybody realized there were two separate reports before that. Who authored the other report, Mr. Lally? Do you know?
I believe it would have been, I'd have to look at it, but either Lieutenant Woodbury or Firefighter Polk, one or the other.
All right. Would this witness know?
I think I have a feeling that he might not necessarily offhand.
All right. So I'll allow his report in. If you need to call Woodbury for just that point.
I don't think so.
All right. And before you go, do you want to mark the other report for identification, Mr. Lally?
No.
Bless you.
everybody was having with
With that addendum, I would seek to introduce and make that as the next exhibit.
Okay.
And, Your Honor, with the court's permission, can I return the report to the witness?
Yes.
Yes, ma'am.
Good afternoon, sir.
Good afternoon.
You and I have met, right?
I believe so.
I wanted to go back to one piece of testimony that you offered on direct examination, if I may.
Sure.
You had, in response to a question from the prosecutor about the medical history and your question to Ms. Reed about whether she had had any alcohol.
We can't see any of the jurors, so everyone that you see on screen are family members and spectators. The jury is on the other side of the courtroom, so we can't see them. So who you see like right behind David Yannetti is the parents of Karen Reed, and this guy that's sitting at this small little table with the computer and everything, that is the defense's IT guy that you see there, just for clarification.
To drink. I believe your answer today was she denied having drank alcohol the night before?
At the time that she was, she could drink, I don't know if she drank alcohol the night before, but at that time I asked if she had any drugs or alcohol, and she said no.
I'm sorry, I just didn't hear.
Yeah, you need to keep your voice up so I speak directly into the microphone.
I asked her if she had any drugs or alcohol, and she said no.
Oh, if she had any drugs?
Well, if she'd taken any drugs or alcohol, she said no.
Did you specify a time period?
I just assumed it'd be in the last few hours for the reason why we were there.
Oh, I see. Okay.
I'm sure she had alcohol days prior, but for the reason why we were there.
Okay. So, was it your understanding that the two of you had an understanding of what you were asking?
Sure.
Jackson moves his
Yeah. So the objection sustained. It's stricken. Ask the question differently, Mr. Yannetti.
Thank you, Anna. All right. So, I guess with regard to your intent and your state of mind when you were asking that question, you were asking, had you taken any drugs or alcohol within the last few hours? That's what you meant to ask?
Objection.
So the objection sustained.
What did you specifically ask?
So when I ask a patient if any drugs or alcohol, I'm talking about that point in time, but an hour before, 2 hours before, not days before, weeks before.
Okay.
So
this was at 6:40.
I don't even know what the objection was, because if the objection was to leading, this is cross-examination. You can lead the witness on cross. So I don't know what the objection was.
In the morning.
Correct.
Did you smell any alcohol on her at that time?
I did not.
Okay. You would agree that she did tell you at some point that she had had alcohol the night before, correct?
No.
All right. So this is now, what's today, May 3rd
No, I don't agree with that.
2024?
Correct.
This happened back in January, on January 29th of 2022?
Correct.
You were interviewed by a Trooper Michael Proctor on February 14th of 2022. Do you recall that?
I recall meeting with him, yes.
And February 14th of 2022 would have been a little bit more than 2 weeks after January 29th of 2022, correct?
Correct.
Your memory of what Karen Reed told you about whether she had anything to drink the night before would have been much better on February 14th of 2022 when you were talking to Trooper Michael Proctor than it would be today, correct?
Correct.
Because your memory doesn't get better over time, correct?
Certain circumstances, sure.
And with regard to whether Karen had indicated that she took any drugs, you told Trooper Proctor she said that she had not, correct?
Correct.
With regard to whether she had had alcohol the night before, you told Trooper Proctor on February 14th of 2022 that she did consume alcohol last night, correct?
Objection, ma'am.
All right, I'm going to see a sidebar on this. Please bring that with you, please.
Yeah, whip this sidebar about.
When the doors closed last time, people went nuts.
What are they objecting?
By popular demand, we are opening.
So, what is the objection?
Your Honor, essentially, counsel is just reading from the report without any sort of indications from the witness that his memory is exhausted as to that or what he told. He is reading Trooper Proctor's report and asking him if he agrees with it.
Okay, the objection is overruled. You can do that.
Thank you.
No reason for this objection. Just time.
With your permission, I'll repeat the question.
Sure.
You told Trooper Proctor on February 14th of 2022 that Karen had told you that she did consume alcohol the previous night, correct?
If that's in his notes.
Well, is your memory exhausted as to whether you told him that?
I don't recall.
If you saw his report with your statements in it, would that refresh your memory?
Sure.
It's a
Yes,
two-page
refresh his
report. I'll give
memory.
you both, actually. It's a two-page report. I'll give you both pages, but I have highlighted a line on the second page, so I would direct you to that. May I approach?
Yes. And take your time reading it, sir.
Yes, yeah. Please leave it
Take
silently
your
to
time
yourself and
reading
look up at me when you're done.
So I did say.
So, Mr. Becker, a couple of things. Wait for a question.
Oh, I'm sorry.
But also,
Sorry.
you have to keep your voice up.
Okay.
I'm close to you and I'm having trouble hearing you. Most of the jurors are further away.
And the way this works is I have to collect that from you and then ask you a question, okay?
So.
If I may approach you.
Yes.
Having reviewed that document, does that refresh your memory as to whether or not Karen Reed, or strike that? Having reviewed that report, does that refresh your memory as to the fact that
Does that refresh your memory?
Does that refresh your memory?
It does.
Okay. And so did you tell Trooper Proctor on February 14th that Karen Reed had told you on January 29th that she had consumed alcohol the night before that?
Sure. Yes.
Okay. Is it fair to say that when you were listening to her talk at times, that her speech was very rapid?
Correct.
And particularly when she had said the words, is he dead, is he dead, she would repeat it repetitively, correct?
Correct.
And she was fixated on that, correct?
Correct.
And with regard to the last interaction that she spoke about with whom you thought she said her husband, she didn't give you any detail about that, correct?
She did not.
You don't know whether it was an in-person communication?
That wasn't my position to ask more details about that.
And I'm not criticizing you, sir. I'm just trying to get to what your knowledge was in terms of the information you got from her. So she didn't specify that it was an in-person communication, correct?
No.
She didn't specify as to whether it was a phone conversation?
She did not.
She didn't specify whether it was a text message exchange back and forth?
She did not.
And she didn't specify whether it was an angry voicemail that she left, correct?
She did not.
No further questions. Thank you. Just one moment now.
Okay.
I have nothing further for this witness, Your Honor.
All right. All right, Mr. Becker, Firefighter Becker, you are all set, sir. Thank you very much. That's okay. Thank you. Yes, you can leave that right where it is. Thank you, sir. Your next witness, Mr. Lally?
May we approach?
Sure.
May we approach? Sure. This is it. We are
Your Honor, just in regard to scheduling,
done in
I know the court. I'm fine to keep going with the next witness, who will be Lieutenant Gallagher. I remember the court saying something about sometime at the end today.
A jury is never going to mind leaving a few minutes early on a Friday. Is that what you'd prefer to do?
That's perfectly fine.
I think rather than starting with his testimony and
Okay, so I'm going to let them go now. You all stick around.
great. Thank you.
Does it make sense that rather than starting...
Okay, so that is the end of the day and the end of testimony for day 4. We're going to pick this back up again next week on day 5 of the first trial, Sidebars. There was a lot to unpack on day 4. The first video was day 1 through 3. So it was a whole lot happening in day 4. Time for second lunch. Absolutely. I hope you guys are enjoying this coverage. If there's something else that you would like to see me cover, if there are other upcoming trials, past trials that you want to have covered here, please let me know. Send me a DM or a voice note and let me know what it is, and I'll look it up and we'll get to it. So thank you guys so much for joining me on this beautiful, cold, almost snowy Saturday. And remember, the world has never met another you. Go out and be great in it. I love you guys. Thank you so much for joining me today. And I will see you back here on a future episode. Stay tuned for our next stream. Bye-bye.